Thank you. There is simply no crime worse than the abuse of children, and there is no duty more solemn for this Parliament, or indeed for our courts, than to protect the vulnerable and to ensure that those who have been so badly exploited, often by the very people in whom they should have been able to most place their trust, are treated with respect and that they receive justice. I commend the Honourable Member for his work in bringing this important matter to the attention of the House and his deep compassion for those who have experienced the most grievous breach of trust. It is a compassion which I hope we all share. This bill focuses on allegations of historic abuse and seeks to limit the ability for a defendant, especially an institutional defendant, to argue for a permanent stay because of the passage of time, the lack of availability of witnesses or other matters. So in considering this bill, it is important to draw on the work of the groundbreaking Royal Commission into Institutional Responses to Child Sexual Abuse. The Honourable Jeremy Buckingham, in his second reading speech when introducing this bill, said that he hopes that it is an, quote, uncontroversial statement to say that the Royal Commission into Institutional Responses to Child Sexual Abuse was one of the most significant, important and consequential Royal Commissions ever to take place in this country, and that, quote, the Royal Commission broke open the dark and often unspoken truths of child sexual abuse in a way that henceforth no one could ever hide behind the protection of saying, I didn't know, end quote. He is correct. This is uncontroversial. And while the stain and the shame of child sexual abuse in our institutions, in our society, will forever be a mark on our history, future generations, let's hope, will be able to look back at this commission and take comfort in the fact that Australia acted eventually and responded, and they will be able to point to this commission as the moment that real change began and that we started to truly address this terrible chapter of our past. That Royal Commission spent 4 years investigating the issue of institutional child abuse. They listened to the personal accounts of 8,000 individuals and examined 134 institutional responses. They considered the evidence carefully, and the Commission's final report made over 400 recommendations for change. This report and these recommendations mark the single most detailed and informed examination of the subject of child sexual abuse ever conducted in this country and indeed in much of the world. The Royal Commission looked at the very issue being addressed by this legislation, limitation periods and stays in civil proceedings. One of the key recommendations made in the Commission's report was Recommendation 85, which said that state and territory governments should introduce legislation to remove any limitation period on sexual abuse claims. The Commission highlighted the difficulties faced by victims of abuse and the lengthy period of time which a victim often needs before they are able to come forward and make their complaint against the abuser. These periods can indeed be lengthy, and times of up to 30 years are sadly not uncommon. The Commission also indicated a belief that the very nature of the crime and the unique vulnerability of the victim means that it is difficult to prosecute the issue within the usual period covered by existing statutes of limitations. And so I'm proud to say that all state and territory governments responded positively to this recommendation, and note that the coalition government in this state amended the Limitation Act to remove limitation periods for child sex abuse claims, as recommended by the Royal Commission. Recommendation 87 from the Commission addresses stays, the direct subject of this legislation. It found that while limitation periods should be removed, state and territory governments should expressly preserve the relevant court's existing jurisdictions and powers so that any jurisdiction or power to stay proceedings is not affected by the removal of the limitation period. Just as we followed Recommendation 85, we should also be guided by the considered work of the Commission and follow Recommendation 87, which would lead us to be unable to support this bill. The Royal Commission did not consider the use of permanent stays was a perversion of the system of justice, but a valid part of its administration, which should be retained. The recent High Court decision in GLJ and the trustees of the Roman Catholic Church for the Diocese of Lismore has provided valuable guidance on the role of permanent stays in matters of historic child abuse. The majority decision clearly provides that permanent stays are a measure of last resort, which will only be granted by the court in exceptional circumstances, and that is exactly the way they should stay. It is instructive to reflect on the facts of this case. An allegation of child abuse said to have occurred in 1968, with the claim filed in 2019, over 50 years later. Due to the effluxion of time, the key witnesses, including the alleged abuser, were no longer available to provide evidence because they were all dead. The defendant sought a permanent stay on the grounds that, because witnesses were not available, any trial would not be a fair trial. But as the court at first instance noted, echoed by the High Court, a fair trial need not be a perfect trial, and so no stay was granted in these circumstances. However, the High Court did indicate the importance of continuing access to stays as part of maintaining a fair trial process and the rule of law. And as the majority noted at paragraph 23, the power to grant a permanent stay is not discretionary in nature and must protect and maintain the rule of law. Quote, "If a trial would be necessarily unfair or so unfairly and unjustifiably oppressive as to constitute an abusive process, a court must not permit the trial to be held. If a fair trial can be held and will not be so unfairly and unjustifiably oppressive as to constitute an abusive process, a court ordinarily has a duty to hear and decide the case." Following the recommendations of the Royal Commission, this Parliament removed the limitation on the period of time in which a claim of child sexual abuse could be brought. But also following the recommendations of that same Royal Commission, did not remove the ability of the court to grant a stay. The High Court has now declared as law for the whole of Australia that stays should continue to exist but should only be a measure of last resort. A measure of last resort if a fair trial would simply not be possible. The decision of the High Court in GLJ is reassuring as it demonstrates that stays are not being granted lightly or easily and that our courts are not allowing them to be used as a means to prevent victims from receiving justice. This is a very difficult issue, and how to address it is complex. We believe that we should be guided in this important task by the considered and detailed work of the Royal Commission. We recognise the pain of those who have suffered sexual abuse as children, and as we did when we implemented the recommendations of the Royal Commission in 2018, we follow the recommendations of this Commission now in upholding Recommendation 87. As such, we cannot support this legislation, though we commend the spirit and the intention of this legislation to the House.